Thank you, Mr. Chairman. Judge Katsubai, I think your fellow nominees owe you a debt of gratitude because many Biden nominees have been extreme, but your record is so far out of the mainstream that you have attracted virtually all of the questions. I was particularly intrigued by your statement to Senator Blackburn that you said you are not, in fact, a Marxist. And then you said, and I wrote it down, I have not praised Marxist ideas. Now, as you know, in law, there is the fact of evidence. And so let's go to something you wrote, an article that is entitled Centralized Property Theory, in which you wrote, it begins, it's on the front page of your law school newspaper, you write, quote, intimate knowing, the lovers kissed, familiar and ever exciting, passionate transcendence, beyond the physical exhilaration lies a burning light in our limbs, our hearts.
The U.S. Senate Judiciary Committee plays a crucial role in shaping the American legal system by reviewing and confirming judicial nominees to the federal bench. These hearings are often intense and highly scrutinized, especially when the nominee has a long academic or judicial record that touches on politically or ideologically charged topics. The hearing in question centers around Judge Katsubai, a nominee put forth by the president for a federal judicial position, possibly at the appellate or district court level. As with many judicial confirmation hearings, senators use this opportunity not just to assess a nominee's qualifications and judicial philosophy, but also to evaluate whether that nominee fits within the mainstream of American legal thought. It's not uncommon for senators, especially those from the opposing political party, to comb through decades-old law school writings, public speeches, journal articles, and legal opinions in search of statements or theories that might hint at ideological bias or radical position. In this particular hearing, a Republican senator is sharply questioning Judge Katsubai about their past academic work, drawing attention to philosophical musings on property theory that invoke Marxist and postmodern frameworks.
In which you wrote, it begins, it's on the front page of your law school newspaper, you write, quote, intimate knowing, the lovers kissed, familiar and ever exciting, passionate transcendence, beyond the physical exhilaration lies a burning light in our limbs, our hearts. Floating, flying, falling in every direction, amorphous and wonderful, time-stretching, space-curving, exquisitely explosive eros. And yet I timidly tremble every time. Now, somehow this is about property, which is not immediately evident as to why, but later in the article you write, you say, property is not simply a relationship between an owner and an object of ownership. Property is primarily a complex relationship between people and secondarily regards the objects people exploit. Historically, three paradigms have dominated European notions of property. Locke appealed to the notion that labor points to who has the right to exploit property. Bentham relied on utility to dictate who has rights based on how the property is exploited. And Marx was plainly disgusted with the alienation that property imposed and its establishment of an us and them and haves and have-nots. Each theory alone denies important components of human experience. Among them are the ability to work, the need for personal privacy and boundaries, and uniquely diverse desires which spin us all in differing life directions. However, the process towards integrating all three may provide a framework for relationships that enhances each unique self. The aspiration towards intimate knowing, the intimate knowing of oneself and others, is a creative struggle towards redefining property. What the hell does that mean?
Senator, when I was preparing and reviewing my materials for this hearing and for the process, I also have to admit that that writing was far from clear or articulate, and the poetry was definitely not good. Now, Senator, I don't make...
Do you believe we need to have a creative struggle towards redefining property, which is what you were advocating for?
That was something that I wrote 30 years ago, Senator, and in the course of just exploring law school and the ideas that came with...
Okay, so your flirtations with Marxism were 30 years ago, so let's go more recent. In 2020, You gave a speech entitled Reflections on Equity and Privilege, and you said, quote, "First, the world is wide enough for all of us. Privilege derives its power from the belief in scarcity, scarcity of money, natural resources, food, and power itself. The desire to control it all drives privilege. I want to suggest to you that equity, the idea of equity, rejects this model of scarcity." Now, that's Marxism in 2020. What did that mean?
I've never considered that to be Marxist, Senator. It's the idea that equal access, and in the context of the work that I do here...
So there is no scarcity, there are no property rights. Equity gives everyone an entitlement to each other's property. Is that right?
Not at all. And in the context of the work that I do on the bench, Senator, when you look at my record for all of these 16 years, you will find that I have upheld the Constitution and our case precedent.
Okay, well, let's turn to something else you wrote in the Wisconsin Women Law Journal. Again, this is your writing. The name of the article is Destabilizing Power and Rape, Why Consent Theory and Rape Law Has Turned on Its Head. You cited Professor Catherine MacKinnon, who argued, quote, "Sexuality itself is a power web in which heterosexual relations per se are infused with violence and control, and, quote, most intercourse is rape." Now, her views are extreme, and yet, and when Senator Blackburn asked you about them, here at the hearing, when you want to be confirmed, you try to distance yourself from them. But here's what you wrote in the article. You embrace those views. You wrote, quote, "I employ the view that rape is sex in order to focus on the significance of consent and rape law. The Sex Act is a violation per se without consent. In order to properly align the consent doctrine in rape law with consent in other areas of law, non-consent must be presumed."
A speech on equity and privilege delivered recently in 2020, which challenges traditional assumptions about scarcity and entitlement. A feminist legal theory article dealing with consent and rape law, referencing controversial thinkers like Catherine MacKinnon. These lines of questioning are not just about legal theory, they are part of a larger ideological battle over the future of the federal judiciary. Conservatives are often wary of judges who seem sympathetic to Marxist ideas, redistributionist economics, or radical feminist critiques of law, fearing such perspectives might lead to decisions that undermine traditional views of property, individual rights, or legal neutrality. Judge Katsubai, for their part, seeks to draw a line between their academic past and their judicial present. While acknowledging that some early writings were abstract, poetic, or even poorly articulated, the nominee emphasizes a consistent record of upholding the Constitution, adhering to precedent, and serving the law, not ideology, in their 16 years on the bench. This hearing thus becomes a microcosm of a broader debate. What kind of thinking should inform the judiciary in the 21st century? Can judges evolve beyond their academic writings? Should abstract or experimental legal theories disqualify someone from the bench? And how do we strike a balance between intellectual exploration and legal responsibility? At its core, this exchange is about trust. Can the public and the Senate trust that a nominee with intellectually adventurous writings will interpret the law fairly, consistently, and without political bias?
Do you believe that is a mainstream view, that heterosexual sex is rape?
Senator, in that article, I was exploring different ideas and theories, and I was employing the hypothetical that you've just described to try to tease out a particular issue with respect to consent. With respect to your last question...
So you also quoted Professor MacKinnon, who wrote, quote, "Sexuality is to feminism what work is to Marxism." Let me ask you again, what does that mean?
Senator, I was summarizing different theories that people were presenting, so that way I could explain them and then employ an analysis with respect to the issue of what consent was in the context of sexual assault back in 30 years ago.
I think your views are far, far out of the mainstream.
Senator Welch.
Thank you very much. I'm going to